Hello and welcome to today's VORES webinar. Thank you for participating in our discussion today on loan modification and forbearance agreements. This is the first of 3 webinars in this year's commercial loan workout webinar series. Our presenters today are Drew Parabeck, Jeff Bezak, and Collie Simmons. Before we begin, I want to cover a few housekeeping items. At the bottom of your screen are multiple application widgets you can use. All of the widgets are resizable and movable, so feel free to move them around to get the most of your desktop space. If you have any questions during the webinar, you can submit them through the private Q&A widget without disturbance to the program. Questions will be answered at the end, time permitting. If you are having any technical issues, you can find answers to common technical troubles located in the Help widget at the bottom of your screen, or you can submit a question through the Q&A widget. An on-demand version of the webinar will be available approximately 1 hour after the program has concluded and can be accessed using the same audience link that was sent to you earlier. Finally, as a reminder, this webinar is for general information purposes only and should not be regarded as legal advice. As always, you should contact your VORES attorney if you want more information or have questions about how these developments apply to your situation. Now for opening remarks, I will turn the call over to Drew Parabeck.
Thank you, Ari. It is really my pleasure to welcome all of you to the first segment of VORES Commercial Workout Webinar Series. We're glad you could join us, and we really appreciate the opportunity to spend time together and share ideas. As Ari said, my name is Drew Parabeck. I guess I'm the elder statesman of this group. During my almost 40-year practice, my focus has been on bankruptcy, restructuring, workouts, and receiverships. And I did some calculation in my mind, and during that time frame, I think I've drafted or negotiated about 500 forbearance agreements. I'd like to introduce my colleague, Jeff Bezak. Jeff is our firm's Swiss Army knife. He does many things very well. Jeff is a former bankruptcy law clerk. He has expertise in finance, bankruptcy, and complex workouts and restructuring. And finally, Collie Simmons. Collie is a rising star in our finance group. She's experienced in workouts and loan restructures, and Collie has the distinction of being our firm's expert on the CARES Act and PPP loans. Perhaps not by choice, but always with a smile on her face. So during the next 60 minutes, we're going to take a whirlwind tour of forbearance agreements and loan modifications. First, we're going to consider things to do prior to drafting, such as distressed credit intake and file review, and due diligence considerations. Next, we'll cover the agreement itself. When are forbearance agreements and loan modifications justified? How do you select the right document? When do you forbear? When do you amend? Or is there something in between? We'll talk about key provisions and tools that ought to go into each kind of agreement, as well as rights and remedies. And we'll wrap it up with hot button items in workouts. We're also going to talk a little bit about COVID, and I am personally interested in your experience during the pandemic and your thoughts on when we're all going to be really, really busy again. Maybe that's something we can discuss offline. Our goal is to give practical advice on how to get maximum protection through these agreements, and at the end of the presentation, we're going to reserve time for your questions. So with that, I'm going to turn it over to Collie to discuss pre-documentation due diligence.
Thanks, Drew, and welcome everyone. Thanks for joining us. As Drew said, my name is Collie Simmons. I'm a finance associate here in the Cleveland office. So I'm going to talk to you about pre-documentation diligence. At the start, I want to caveat that these tips are really, generally intended for loans that are hitting your desks for the first time, but of course can also be used for loans that you haven't touched in a while or really just want to refamiliarize yourself with. And we'll touch on all of these items in more detail, but generally first you're going to want to do a loan file review and get your arms around what documents and agreements are in place and kind of get an idea of all the key players and what's going on. You'll also want to do an organizational and legal authority review to make sure that all of the entities had proper authority, not only to execute, the original documents, but also any modifications, any letter amendments, anything like that. And you'll also want to look at the real and personal property searches that already exist to get an ideas of what entities were searched, where they were searched. It may give you an indication of locations or prior names that you didn't know existed just by looking at the face of the loan documents. And what else showed up on the original searches? Was there existing debt that was paid off? Were there equipment filings that remained in place post-closing? Another thing to look at is, do you have supply chain and collateral access agreements in place? This is particularly if you're relying on tangible collateral. If not, this is a really good opportunity to get more information on, your missing agreements, either before entering into the new documentation or, on an ongoing basis as you monitor the loan. And then do you have, both recent and historic financial performance reviews so you can kind of keep tabs on, how things have been going in the past and how they're going now. It's important to keep in mind that if you're working with outside counsel, you'll likely be working with them on numbers 2, 3, and 4. But if you're not working with outside counsel and this is just an internal review, you'll want to make sure that someone internally is looking at all of these items and has these on the top of their mind. So when we look at what's in the loan file, you'll want to, audit all of your loan documents. You can keep kind of a checklist in mind and look at, have they been properly executed? Again, was there appropriate authority at the time of execution? Where are the originals of both the original signature pages, but also possessory collateral documents? Take note of anything you're missing. Are there any collateral or perfection issues? So if you are taking vehicles as collateral, for example, have you notated your security interest on the title documents? If you have a pledge of a certificated entity, are you holding the stock or membership certificates and a blank stock or membership power? Again, do you have current financials? Do you have evidence of insurance? Has the insurance lapsed? Do you have evidence of renewal? Does the evidence cover all obligors and locations? If you're relying on insurance proceeds, are you listed as lender's loss payable? Do you have proper insurance endorsements? And then it's important to identify all material communication, particularly if the credit is in deep distress. You'll really want to get your arms around any email communications between your team and the borrower. And this can help you, identify any potential lender liability issues. And then also, if it's a new to you credit, this can help you understand kind of the tenor of the existing relationship, whether it's friendly or hostile, if there have been any issues in the past. And then just taking note of any missing documents or missing agreements or anything that you find that's particularly noteworthy. So looking in the loan file, this is a really good list of examples of documents that you may find in the loan file. Overall, really your goal is to discover what has been documented, but also what hasn't. And this is a really good opportunity for you to patch any holes that you may find before any deep distress, or to identify any potential issues that you may not know about. For example, you might come across a subordination agreement and not have known that there was a subordinated creditor, or you might find out that you don't actually have a landlord waiver in place for a large facility. So it's important to, keep note of what you do have, but again, any glaring things that you're missing. So next, you'll want to do due diligence searches, especially based on what you find. Generally, your loan documents will require that the borrowers disclose items that you would probably find in these searches. But I'm sure, as you've found sometimes in practice, this isn't the case. These searches can help you identify any new lenders, any new relationships. For example, you might find out there's a new AR factory agreement that you didn't know was in place that is now showing up on these searches. This could help you identify any active litigation that wasn't disclosed, any acquired IP that wasn't disclosed, and really a variety of other information that you may not have known about if you had only really relied on the borrower to disclose, pursuant to the loan documents. And then additionally, there are two items that are not necessarily diligence items, but we think are really important, which are ordering just a good standing certificate and certified articles. So for the good standing certificate, not only do you want to know if the company is in good standing, just generally, but this is also hugely important in certain states because certain state law actually requires that a company be in good standing in order to execute any agreements, and says that any agreements that are executed by an entity while it's not in good standing is invalid. So this is hugely important to make sure your company is in good standing, especially if you're entering into any amendments or new documents. And then with respect to certified articles, this is really important, and hopefully it's not the case, but you can find out that something very drastic has happened, like the company has changed its name without your knowledge. And so, finding something like that out can help you figure out that you need to amend your UCC filings, amend your any other security filings, and make sure that you are still perfected all the way around. And so next, I'm going to turn it over to Jeff to continue discussing loan file considerations.
Thanks, Collie. So as Drew introduced, my name is Jeff Bezak. I'm an attorney here in our Cleveland office, and I do split my practice between our front-end transactional practice and our bankruptcy and restructuring group. So I get a little bit of exposure on each side of the fold here, healthy credits and credits that might be experiencing some distress and how to handle those. So, carrying on and sort of putting a bow on the discussion of what's in the loan file, as an overarching matter, we'd encourage you in doing all of this to take a fresh and objective look at the loan. So this is not just in terms of taking a fresh look at what your borrower's been doing, what their performance and prospects are like, but also taking a look at what you as an institution have done and how you've handled the loan to date, and identifying any issues either with your customer or with the way the loan's been handled to make sure that those are being taken into account when you formulate your overall workout or exit strategy. So chief among those items is going to be, why are we here? What is the reason for your customer's distress? As we'll discuss a little bit more later, if your customer is in distress and that distress seems to be terminal, that might change whether or not you consider entering into a forbearance agreement. It just might not be worth forbearing from the default if there's no hope of the borrower getting back in your institution's good graces. Like I mentioned, identifying lender liability issues and potential claims against your institution. Collie had mentioned tracking down material correspondence. Getting the written correspondence is helpful, whether that's email or something that's actually tangibly sent via mail. But also understanding if you're not the first person or the person that's been handling this loan since inception, talking with the individuals that did and making sure you get a good understanding for were there oral promises made to the borrower, even if in passing on a phone call. Is there a close relationship there where things might have been handled in a way that, we talk about relationship banking, but maybe it went a little beyond traditional relationship banking and there were some agreements made or understandings or even just interpersonal sensitivities that are going to be helpful for you to know as you formulate a strategy of how to deal with this particular credit. And then lastly, and this really ties in nicely with Collie's discussion about the searches, as you can imagine, when a loan goes into distress, it's not only often the bank or the lending institution that is going to be having issues with this particular borrower. You're also not uncommonly going to see lawsuits from vendors, lawsuits from customers, competing creditors potentially taking enforcement actions against the borrower. So all of this is to say is if you don't gather this information up front, it's going to be really hard to formulate a strategy and prepare documents that get you where you want to go. So having that objective, fresh look at the loan file is really, really critical.
So the question, should you meet with the borrower? When the three of us were preparing for this presentation, my initial reaction was every case is unique, but yeah, of course, you'd want to meet with the borrower, especially after COVID and 2 years of not meeting. And I've kind of found myself wanting to meet with just about everybody. But as I thought about it more and more, I think the answer may be you do want to meet with the borrower unless it would make matters worse, the relationship has deteriorated, the loan has deteriorated, there's been fraud, improper conduct, criminal activity, you filed an SAR, you've been threatened with litigation or personal threats, and the situation is hopeless and the credit is dead on arrival. But having said that, I still think, based on my experience, that meeting across the table gets a lot more accomplished, especially if the borrower is acting in good faith and is really trying. I think an absence of meeting during COVID was a real negative. And then I guess I would also say that if the parties just really can't be in the same room together, it's a time to get the attorneys involved. Liquidation versus forbearance. I guess the question there would be, will extra time help solve the situation, or are you better off just taking your lumps and getting it over with? I think that depends a lot on whether the bank has its house in order. The borrower story is very important, and it's something that you really, really should listen to. Why is there a problem? Was it a blip in the business or the economy? Are there supply chain issues? Does the borrower have customers in trouble? Is there a COVID hangover? Like the money is gone? Or has there been mismanagement or bigger problems? And perhaps more important than that part of the story is, what is the plan to fix it? And do you think that your customer has honesty, integrity, horsepower, and credibility to solve the problem? And then establishing ground rules for a potential workout. I think it's important early on to set expectations and to understand who's going to speak with whom, how often, will it be oral or written? We'll talk a little more about that. Are the attorneys going to be involved at various stages or every step of the way? You want to get an understanding of reporting. You want to schedule for reporting and other benchmarks. You've got to stick to it. And there really has to be transparency on both sides of the equation, both the bank and the borrower. And I will tell you, based on my experience, banks really don't like surprises. So communicating with the borrower, best practices. I would start with something my mom taught me many years ago. Don't do or say anything that would embarrass your mom. That's a best practice, and it's pretty simple to understand. You want to avoid ambiguity in oral communications, and as I mentioned, transparency and trust are paramount. You want to be clear and consistent, and that's also the same for written communications. You want to confirm written conversations in writing, and I'll refer to something my dad taught me. He was a 60-year lawyer over in Lorain County, and his 3 rules of good lawyering were get it in writing, get it in writing, get it in writing. I think written communication is preferred. I think if you're dealing with difficult and litigious borrowers, everything has to be in writing. You don't want to make a bad situation worse. You don't want to create confusion or misunderstanding. And again, I think that's a time when attorneys have to be involved. I'd also talk for a second about ambiguity in drafting the forbearance or modification agreement. And this is something Jeff and Colley probably would say is impossible, but I really don't like words like material, reasonable, best efforts, in good faith, I agree, to the best of my knowledge. I think that all creates potential ambiguity and wiggle room, and I do understand that sometimes you can't get around that. In all things, you want to stay professional. Calling your borrower a crook usually will not advance the ball or get a deal done, and I've actually seen that happen. And I want to talk a second about privilege. If you are communicating with outside counsel in anticipation or in the midst of litigation, those communications are probably going to be privileged. If you're communicating with internal counsel on the same kind of topics during the same context, I think you've got a good argument that those conversations are privileged. But if RMs are speaking with each other, or you're talking to people who aren't your attorneys in a matter, those communications are not privileged. So be careful what you say. And when it comes to emails, the same rules apply, except you need to be very careful what you say. And we've seen some real doozies when it comes to emails. But you have to assume that they will be an exhibit at trial for a judge and jury to see. So again, really be very cautious in what you say in emails and in any communication.
You know, to put a bow on what Drew said, even beyond emails and other written communications like a letter, text messages, Teams messages, your assumption should be that if you're not in those limited contexts where privilege applies, that whatever you're saying could be up on a PowerPoint in a bankruptcy court or in front of a judge when you're working this out and things are in litigation or they filed for bankruptcy. And this goes back to what is the story of the borrower. You do not want the story of the borrower to be, we were trying to fix our business. You, lender XYZ, you got in the way of us fixing it. And here are all these text messages and emails that show that you didn't respect us. You were trying to hinder us along the way. You made this more difficult for us and put us in this position. Not only is it going to look bad in conveying that story to the judge, but it may also open you to lender liability and other claims against your institution. So again, you know, all of us have those frustrations with some really difficult borrowers, with their counsel. But again, if you are putting it in writing in any format, be extremely careful what you say and assume that at some point it could be put in front of individuals that are going to be evaluating whether or not you did your part to be a good business partner with your borrower. So on that subject of communications, you know, there's a couple different other routes of communication or things that might go out when you enter a workout or as the workout progresses that you want to keep in mind, and all of these same rules and same general principles apply. So initially, you know, the most basic you might think of when a loan hits some distress would be a notice of default. And again, this is another good place to stop, because I won't tell you how many times I've had a phone call where the bank has become aware of a covenant breach or some sort of reporting breach. And, you know, the first words out of their mouth are, well, we've got an event of default. You know, to quote Lee Corso, not so fast, my friend, take a step back, pause. You may have a breach of the agreement, but you may not actually have an event of default. You know, this would be a great time to stop and check your loan documents and see, do I have to give notice before this breach becomes an actionable event of default? Most times in most sophisticated loan documents, that's going to be reserved for your more minor defaults, and your critical defaults will be no cure, no notice defaults. But it's always good to check, because the last thing we'd like to see you do is take some sort of action when you don't actually have an actionable event of default. Hand in hand with that is the reservation of rights letter. You know, our general recommendation on matters and our general practice when we're handling things is you should be reserving your rights every step of the way, every time you become aware of a new event of default. And that doesn't have to be a big, bad, nasty message to your borrower if things are still amicable. And this is more of a bump in the road than a permanent crashing of the credit into a dark place. You know, these letters can be scaled by your counsel to protect your interest, but maybe not necessarily inflame the sensibilities of your customer. You know, similarly with that, cure letters, in some cases, the covenant may be subject to a cure, whether that's just the burn off of a certain period of time, or an equity cure right where a third party might be able to step in and cure financial covenant defaults via capital contribution or other monetary act. Something to be mindful as well, is there a notice there? Is there time that needs to be spent before the cure period runs, or even the cure period starts and the default eventually occurs? And then additionally, imposing default interest. You know, a lot of loan documents will provide that default interest either starts automatically upon the occurrence of an event of default, or can be implemented at the lender's option, but doesn't explicitly require delivery of a notice to the borrower. You know, every situation is different, but I think as a general rule, if you are charging default interest, you should be very strongly considering providing a notice to your customer that you are doing so, even if it's not required. You know, the last thing you want, again, tying back to the story, is a surprise that all of a sudden your customer's interest rate on their outstanding balance on the line of credit has gone up anywhere from 2 to 5%, and they're not finding out until a month later when they get their next payment statement. Again, transparency and being forthcoming is really, really important at these early stages, but particularly if there's a relationship that can still be salvaged. Acceleration and demand letters, this is getting a little bit farther down the road from the original notice of default. You've got a matured event of default here. But again, if you're accelerating the loan, if you're making demand under a demand line of credit, whether it's got events of default or not, again, those should all be documented in writing, and you need to be following the letter of the loan documents to the T. And lastly, these communications, so payment blockage notices, not necessarily going to be communicating with your borrower, but this is where it's really important to understand what other creditors might be involved and what rights you have vis-a-vis those creditors to block potential payments. So the common ones we're thinking of here would be a management fee subordination arrangement, seller debt if it was originally an acquisition finance or there have been add-on acquisition transactions since the loan originally closed. You know, any right that you might have to prevent cash from leaving your borrower. So again, there's a tangible benefit to you, but you're also making sure that you are complying with your obligations if you choose to have your borrower stop making those payments, that those third parties are appropriately put on notice. And hand in hand with that, we would note that in some instances, though it's not terribly common, particularly in a seller or management fee subordination type of arrangement, it may also be possible that there are third-party creditors like a mezzanine lender that are entitled to notice of the occurrence of an event of default. And again, we want to make sure that those notices are going out. We're aware of those notice obligations, and you're not exposing your institution to litigation risk just because you forgot to send out a notice for a default that you'd known about, and you know it was something that very easily could have been sidestepped.
So what are some overarching considerations that you should consider in determining whether to forbear, to amend, or to pull the plug? I guess the first one I would go into would be, does our borrower's business have a future? And there are a lot of tangible and intangible things to think about. Are you dealing with good people? What's going on in the industry? Is this a business flip? How is the economy in general? It's just bad luck. Or are you dealing with scoundrels? And as a general rule, you don't want to get into bed with bad people that you don't trust. Also, where are you in the workout process? Has collection already started? Has there been such deterioration in the credit that it can't be rejuvenated? And the same thing goes for relationships. So are you really prolonging the inevitable, or is there something there to fix? Do you have a strategy? Is it a real strategy on how to get out of the situation you're in or to retain that situation? Or do you need a little bit of time, perhaps a placeholder, to come up with a strategy, to work with the borrower, and to fix any problems that you may have with your documentation or your collateral? And documentation and diligence can be a strategy. You've got a perfection glitch, you need more collateral, or you want guarantors, other protections, you can use a forbearance arrangement to get those. How much is too much? Well, one of, I think, our most important jobs as attorneys is to keep our clients out of lender liability trouble. So I believe several axioms apply. One, I always presume that my clients, my bank clients, are acting reasonably and in good faith. And I don't think I'm giving them too much credit because I think banks generally want to do the right thing. Control is really an ugly word. You can't run your customer's business to its detriment. You just can't do it. The third axiom is pigs get fed and hogs get slaughtered. And I think that's self-explanatory. And again, I think you really do need to rely on counsel so that you don't step into bad situations that can be avoided.
All right, so once you've given thought to those considerations, one of the next steps you might take is figuring out what type of document best fits your strategy and your credit. And you know, the first type of agreement on here can be the ugly F word when it comes to workout, and that is forbearance. And that immediately you're triggering with your borrowers. There's a default, there's trouble. You know, a forbearance agreement might be the right approach, but there are other types of documents you can use that in many cases can get you a lot of, if not the same protections, but without that stigma or, you know, triggering effect that the use of the word forbearance might have with them. So if you want to think of it on a spectrum, The forbearance agreement you can consider on the stronger end. And so that's going to have your full range of legal rights and protections, all of your disclaimers, acknowledgments from your borrower. You're going to consider that your stronger medicine. Right up there with the forbearance agreement, and it can be scaled all the way down to something really closely approximating an amendment you would do for a healthy credit, would be what we'd call a hybrid document. And you might see these in the wild by the name of a loan modification agreement, an agreement regarding loan documents, even something just titled an amendment but has contents that are different. Whatever it is, this can be a really helpful tool where the use of that F-word forbearance is causing an optical issue, and framing the document as something else while giving yourself the protections that a forbearance agreement would provide, or maybe some of those protections that you need, can be a really effective tool to get particularly borrowers that are experiencing turbulence for the first time over the hump of the fact that, yes, you are in workout, this credit is distressed, but we're not going to frame this as a forbearance. We're going to be working with you to try and either rehabilitate this credit, or if it's your strategy, to have them exit your institution and find a new lender. And then on the lightest end, you've got the amendment and waiver. And this really should be reserved for situations where the default you have is a bump in the road. There really aren't concerns about the long-term viability of your borrower at this point, or even the short or medium term viability for that sense. And you're confident that the default is resolved or is going to be resolved, and you're going to waive it. You might build in a few additional protections and monitoring mechanisms, but the amendment is not intended to buy additional time to execute a strategy or to begin preparations for a liquidation. It really is getting your borrower back on the line as soon as possible. So with any of these documents, like I said, the forbearance agreement is going to have all of these, and then your other documents you can scale to include what you need. But the most common items that are going to be involved here, first and foremost, and really it's our position that you need to have a recitation and an acknowledgement by your obligors of the defaults, particularly if you're going to agree to be waiving them. We've had a number of instances where borrowers have asked for a waiver but will not admit that a default occurred, whether that's credibly or lacking credibility entirely. Our position is across the board, if you are offering relief from a default, at a bare minimum, your borrower should be acknowledging that one happened. So at a minimum, if things were to deteriorate, your forbearance expires, you're left exercising your remedies, you aren't faced with the foundational question of, do we actually have an acknowledged default that we could take in front of a judge or lean on to exercise remedies? So hand in hand with that, whether you're forbearing or whether you're waiving, the next key component is that forbearance or waiver. So you're going to be making clear, first and foremost, that that single forbearance or that waiver is not a waiver or forbearance as to any default they haven't disclosed to you, that you haven't learned of, and it's not going to impair your discretion in considering those waivers or forbearances in the future. You're also going to want to consider not just when to waive, but how long to forbear, and whether you're going to maybe waive some defaults and forbear against others, depending upon the scenario. We hate to see our clients come to us with a strategy that contemplates a long-term forbearance without a real objective as to where that forbearance is going. We don't really see great value in forbearing on a default for 6 months where there aren't concrete steps put in place to get your borrower from A to B where you want them to go during that period. As a result, we generally like to see a shorter forbearance period. And it's simple enough for your counsel to extend that forbearance period as it's necessary throughout as the workout progresses. But that helps you have that sort of carrot and stick approach to encourage your borrower to do the things you want them to do, whether it's to rehabilitate their business or to find sources of exit financing. You keep the leash short and make sure that you're not giving your borrower a license to do whatever they want for 6 months and be back in the same place 6 months later, but potentially with devalued collateral or worsening financial performance. The last two items here trend more into the legal territory, but they're important, and we mention them because they can be really critical in cases where the documentation as it came to you might not have been in perfect shape. One would be an acknowledgement of existing obligations. So you want to cut off any argument that there's a dispute as to the total amount of debt owed, and you want to cut off any argument that they have not reaffirmed and acknowledged the liens that they previously granted to you. on collateral. Again, those can be valuable tools if things progress to a really serious workout state or litigation, that your borrower has essentially admitted that they owe the money and they have not reserved any right to contest the lien that they've granted to you. And lastly, the release and waiver. So the release and waiver are critical, and they're doubly critical if you're following the steps we've outlined and you've identified internal communications and any potential lender liability risks. We can scale releases as counsel to fit the situation. An amendment and waiver might have a very vanilla, simple release, whereas a forbearance agreement where the situation's deteriorated, there's potential claims against your financial institution. That's going to be a longer waiver and release, and there's going to be included a covenant not to sue, all the belts and whistles to make sure that when you are providing the relief your borrower is asking for, you are getting a reciprocal waiver of claims they might have against you. So, our position is you should not ever concede on some sort of release and waiver if you're providing relief, whether it's forbearance or waiver from a default. It's just a question of scale as to how in-depth and how lengthy that release is going to be and what it's going to cover. So digging into the nuts and bolts of these documents. So really, you should be viewing any of these types of documents as the opportunity for you, first and foremost, to gather more information about your borrower, to either initially inform your next steps if you're kind of coming into the credit a little bit cold or the reporting to date hasn't been great, or if you've got great existing information and you need more to help further inform your strategy and make sure that your plan at the outset makes sense as facts change, it's the opportunity to implement a new financial covenant, to implement new financial reporting or increase the frequency with which it's delivered. Liquidity and free cash flow monitoring. If you don't have reporting in place to know what's happening with your borrower's cash on a real-time basis, this can be an awesome opportunity to step in and put in something like a 13-week cash flow and a variance test that gives you the ability to monitor your borrower's cash and liquidity on as close to a real-time basis as possible without being inside the building. Similar with that, once you've got that information in place, you can use these documents as a means to restrict cash outflows, particularly with your borrowers where the distress is really a liquidity problem. So we talked before about the notices you're sending, payment blockage notices. Are you going to be sending out notices to block payments? If you didn't do so before as part of the arrangement, are you going to be asking for new restrictions on making subordinated debt payments, on making management fee payments to a sponsor? These are all measures that at the margins may not ultimately shift the tide of whether the credit sinks or swims, but they can provide your customer with a little more breathing room by exercising the rights you already have in your documents. Similarly, if liquidity is a problem and you need to bring more liquidity in, it can be a great opportunity to use your leverage to get the liquidity support your borrower needs. That could be in the form of an equity injection. We'll see keep well agreements or make-wholes where they have a third party, often a sponsor or equity owner, that's agreeing to provide liquidity if there's a financial covenant default. And that can really be scaled to be as expansive or as narrow as you and your customer and that third party would like to have. But again, it's providing an additional collateral source of liquidity for your borrower. And then, if things internally with your customer seem to be like they might need a helping hand to get on the straight and narrow, maybe there's been a change in management since the loan was closed. So, someone has left that was critical to the operation and things have gone a little bit sideways. It can be a great opportunity, particularly with the forbearance, to bring in a turnaround consultant, a CRO, or another professional to provide that advice and counsel to your borrower. With a caveat, going back to Drew's comment regarding control, the idea here is that the consultant is going to be supplementing the existing management team and helping them execute on the shared strategy to get the loan back on the line or get the bank out of the deal. It is not an opportunity, and you should not be viewing the engagement of these professionals as the bank getting an inside person at your borrower to help call the shots. That's where you're trending into control, and lender liability concerns become paramount, particularly if that consultant, even if it's someone you've trusted and worked with for a while, doesn't give the best advice or things just happen to go south. You do not want to be exposed to a claim that this professional is really your professional and it's because of the advice they provided or didn't provide that the borrower's situation got worse and something bad ultimately happened. So again, it's that give and take of getting the additional expertise in there and encouraging and at times requiring your borrower to get someone engaged versus the bank dictating who's involved there and really calling the shots vis-a-vis this third-party professional in a way the bank couldn't do via your own loan officers.
Legal rights and remedies, I think, are very important. The ability to get them through a forbearance or other amendment is critical. It's a checklist of potential game changers. Many of these topics could be a seminar in and of themselves, but I want to discuss each one, often in a common sense kind of way, and then give you a couple of key takeaways. So when it comes to common sense, if you need a guarantor and don't have it, or that would help shore up your situation, try to get a guarantor. Try to put that right in your forbearance agreement. My experience has been that even if the guarantor does not have much in the way of financial wherewithal, there's a psychological aspect to having a person sign on personally to the debt obligation. It gets their attention, and I think they're usually more agreeable and compliant in what you're trying to do. Same thing goes for collateral. If you don't have enough, you need it, and you can get it, ask for it. Cross defaults and cross collateralization, this is often missed, especially when lending relationships evolve and new obligors are added, or the bank may add related parties that weren't part of the original loan package, such as equipment finance companies. Remedying perfection issues, again, pretty straightforward, and I think that Cauley has touched on a lot of this, but you do want to check your financing statement. You want to make sure it's been continued. You want to docket deadlines for continuation. Take a look at the collateral. Is it unusual? Is it a kind of collateral that simply filing a financing statement isn't going to get you perfection? And has your borrower moved? Has the collateral moved? And have there been name changes? But look for different situations that are not run-of-the-mill. Bolstering contractual rights and remedies. Receiverships are something we see very often in this area, especially in a middle market economy where bankruptcies are pretty expensive. They've got many advantages. Receivers can sell property free and clear of liens. Orders entered in a receivership case can give you insulation from lender liability. But you have to remember that you can't always get what you want. And even though you may have the best receiver for your situation, that doesn't mean the court is going to go along with it. Things have gotten better since the statute was amended a few years ago. But again, there's no guarantee that you're going to get the best person to run the show. Public and private sale rights, you want to put that in your agreement that you have the right to do that through Article 9. I don't see that all that often, but it does work. You can sell assets quickly, free and clear of liens. And in the agreement, you want to get as many waivers and notices as you can from your borrower. Cross guarantees and suretyship waivers, again, you're shoring up your position. Cognovit and confession of judgment rights, that's something we have in Ohio and only in a handful of states, but typically it works. That statute is strictly construed. I think you need to be very careful if you use Laser Pro documents because they're not always set up the right way in terms of where you sign and where the warning goes. If documents are amended, again, be careful. They need to be set up properly in terms of signature and where the warning is and really where they're signed. You need to know your state. In Ohio, it's pretty well established that this works, but you got to be careful. Some judges don't like it, and in some states, it's actually illegal to try to take a Cognovit judgment. And then a more recent development is, what do you do with e-signatures? Is that good enough? Our experience has been so far that, yeah, you can take a Cognovit judgment with an e-signature. But again, some judges don't like it, and I can't guarantee that's going to work in every jurisdiction. In the unfortunate event, God forbid, that you do get sued as a lender, you want to find yourself in federal court in front of a judge, not state court in front of a jury. Federal court with a judge, I think you're going to find a more sympathetic ear when it comes to deciding lender liability questions. And then forbearance and amendment fees. they can be used to incent certain behavior in the lending relationship. We put that as desired outcomes in our PowerPoint, but you can incent a customer to leave by charging fees that are material. You can create benchmarks so that if certain requirements, deadlines, compliance is accomplished in a timely fashion, some of the fees can be reduced or rolled off completely. I think that the key here is what is reasonable. And I don't know that you have an exact percentage that is reasonable. I tend to apply the smell test. Some people say that if you're charging 1% of the commitment on an annual basis, that's a pretty good guideline that it's reasonable. But I don't think that's cast in law by any means. But I think these fees are normal, and I think customary, and certainly can have an impact on how the relationship comes to an end or progresses. I guess a couple other points real quickly. I often put bankruptcy waivers in my agreements, such as if the customer goes into bankruptcy, you get stay relief automatically. I don't know that those work very well, but I put them in there anyway. And then I think another thing, and this is probably self-explanatory, but you want to have control of the cash. You want the deposit accounts to be at your institution, and if they're not there, you want a control agreement. So with that, on to hot button issues.
Thanks, Drew. So one hot button issue that we're going to touch on is, of course, LIBOR replacement and SOFR transition. Of course, many loans have already taken care of this transition, but it's really particularly important to think about it for loans that are new to you or loans that you haven't touched in a while. So as you probably know, many times the parties can kind of kick the can down the road and plan to transition LIBOR to SOFR or other replacement at some time in the future. But while the deadline to transition is really rapidly approaching right now, generally this is still an option depending on the substance of the amendment. Some rules, though, or under the current rules, though, some amendment provisions may trigger a requirement to amend the documents and transition away from LIBOR. So these are amendments that either increase the debt or extend the maturity date. And in our experience, the second trigger especially is really important because LIBOR transition is really something that you need to think about ahead of time because, you know, it's usually a lead time item. It takes time to incorporate the new language into your documents, especially if these documents and forms are unfamiliar to you, or if these are credits that have been around for a really long time and are documented on older forms. So really, this is something that's pretty tough to get done if you are in a situation where you're extending a really rapidly approaching maturity date and you don't really think about the LIBOR transition until a day or two before maturity. And this is something that we really recommend prefacing with the borrowers. So, you know, LIBOR transition at this point is pretty standard for banks and is something that they have really dealt with for a while now. But many borrowers may not actually appreciate the transition. You know, as I'm sure all of you know, there is much more involved in transitioning LIBOR than simply searching the word LIBOR and replacing it with the word SOFR. And we have seen instances where the borrower either wasn't prepared for, you know, the time or costs that may be associated with the transition, the fact that multiple documents, including notes, may have to be amended, or really just seeing an amendment come across with a ton of red lines when they thought that the plan was changing the maturity date from 2022 to 2023. So this is something that we really recommend talking to them about ahead of time. And, you know, this sounds obvious, but it's also important to make sure that you and the borrower are on the same page about what you're using to replace LIBOR. You know, you may think it's obvious and standard at this point that you're going to SOFR, but the borrower may think that you're going to prime or something else. So this is something really to think about ahead of time and stay in open communication about. And then lastly, just as a shameless plug, Voorhees has a really outstanding LIBOR transition team and has done a ton of work in the space. So please feel free to reach out to any of us on the call or your Voorhees attorney with any, specific questions or considerations on that front.
Thanks, Collie. So to wrap up the hot button issues, one, which I'm sure is top of mind for everyone, and particularly whether you're in-house counsel at an institution or the in-house counsel at your institution, the impact of sanctions, AML, KYC compliance, and then COVID-19 generally. So as to the former, the workout scenario can be a great time to reassess in reviewing the supply chain issues that your customer may have. Do they have supply chain issues that relate to Russian sanctions, or God forbid, are they continuing to do business, whether it's with suppliers or customers that are located in Russia or affected territories in Ukraine that are subject to sanctions? Generally speaking, OFAC and government institutions are going to be looking for you to be making a good faith effort in trying to address these issues and stomping out those that are foreseeable to the bank. So, it's just a baseline matter. Updating your documents with the latest sanctions provisions is a great idea, but also just making sure you understand your borrower's supply chain and customers, and that you aren't inadvertently assisting your customer with circumventing or directly violating applicable sanctions. When it comes to COVID-19, looking back through the last time we did a similar presentation, it was in the heart of the original lockdown, and we probably had an hour on PPP loans and EIDL loans and all of the different trappings that come with the various pandemic-related assistance the government provided. Thankfully, particularly for the attorneys, I think a lot of that is behind us. And, we're not considering so much about the PPP loans nowadays. But supply chain issues and just the general lingering impact of COVID-19 can still be relevant. One item I'd urge you to think about that might not be top of mind, but we've been seeing it increasingly frequently, are in your financial covenant calculations, particularly in a workout where you're doing a reset of covenants or adjusting calculations. You may have carve-outs or add-backs in your EBITDA and other cash flow calculations that allow for unusual or extraordinary recurring costs and expenses. And we have seen attempts to shoehorn unusual and extraordinary costs related to inflation, related to supply chain bottlenecks, related to labor shortages, all sort of tied up into those add-backs that really aren't supposed to be there. So this can be a great option, and I know this is a little bit granular, but considering how those impacts might be affecting your customer and whether or not it makes sense from a documentary perspective to not give your customer the flexibility to essentially manipulate what their financial reporting is to you based on impacts of things that really shouldn't be considered an extraordinary or not recurring cost. And lastly, this is one particularly for the lawyers on the phone, but everyone should be aware of it as these assets become more popular. Your digital assets, like cryptocurrencies, your Bitcoin, Ethereum, you name it. The Uniform Law Commission has just recently approved draft language for a new UCC Article 12 that deals with digital assets. Again, this is a lot for the attorneys, but it's good to think from a business perspective as well. If your customer has material digital assets, different rules are likely going to apply to those assets when it comes to attachment and perfection of your liens. So if that's something that you're going to be relying on in a liquidation or as support potentially for an ongoing credit, talk with your attorney. Make sure that if your state is a state that has adopted UCC Article 12 or is expected to do so imminently, that you're complying with that so you don't wind up in a liquidation and not perfected or attached with your lien as you thought you might have been.
And before we get to questions and answers, I'd like to add a couple things to this list. One is continue to be cognizant of flood insurance requirements. And the second thing, and this is following up on Jeff's comments about COVID, but I hope we're now in a post-COVID world. I think there are many unanswered, more general questions we have to consider. But during COVID, there was a boatload, as you know, of PPP money. It was life support for a lot of unhealthy companies and probably served to mask problems. I think banks were kinder and gentler, either because they wanted to be or they had to be. And extend and pretend was kind of the norm for a couple of years. If COVID is truly over, and I believe it is, We're in a post-COVID environment. The PPP money is largely gone. I think it worked, but it's largely gone. And I guess I wonder for lender clients, are we going to revert back to pre-pandemic practices? And are we going to see distress that perhaps was covered up by the PPP money that kept things afloat? So we're heading into that era. I guess we'll soon find out. And with that, if we have questions, we'd be happy to entertain them.
And we do. So we've got a number of questions here. So we're just going to pick off a couple here in the few minutes we have left. So the first one we have is, should lenders be dictating to their borrowers which third-party consultants they should hire? I guess I can start on this one. So you absolutely should not be dictating to your borrower who they should be hiring. Now, that's not to say you shouldn't have a role in guiding your borrower to a consultant that makes sense for their business and someone you have confidence in. So this is both a business issue and a legal issue. When it comes to the legal issue in your documents, the way we typically frame it is that the engagement of the professional is by your borrower, they're paid for by the borrower, they're managed by the borrower, and they have reporting rights to you as the lender. And generally speaking, they're going to be required to engage a consultant that is reasonably acceptable to you. And what we like to see is whether the borrower comes to you with a consultant that's fine with you, or you provide a general list of several consultants that you've had a positive experience with, and they choose that consultant. You can note in the loan documents that, for the avoidance of doubt or to clarify, consultant XYZ selected by the borrower is reasonably acceptable to the bank. Again, it should be a partnership. You should be advising them, and you want to have a consultant in there that's going to work for you, but you cannot be dictating to your borrower who they're using, and you cannot be using that consultant as a vessel through which the bank is secretly controlling the operations of the company.
I would add to that a lot of banks have a rule of three. It may be 4 or 5, but they will say to their customer, we want you to get a consultant. These 3 or 4 or 5 consultants are on our approved list. They're acceptable to us. I think that also applies to a number of judges when it comes to choosing a receiver. They want to be given 2 or 3 or 4 different alternatives, and then they make the choice.
And maybe it goes without saying, but to further to Drew's point, a list of 1 is not a choice. That is dictating who they choose. So yeah, 3, 4, 5, however it is, make sure it is your borrower that is ultimately selecting who they're going to be working with. And it's in your interest as well, because if it's not someone your borrower can trust, you're unlikely to get to the ultimate end goal you want from having that consultant or CRO on site. Let's see, another question we had was, can you please discuss when it may be appropriate to engage different counsel for a workout than the lawyers or firm who initially prepared the loan documents, including to perform an unbiased review of the original loan documents? I guess I would say generally on this, we see different policies for lenders we've worked with over the years on how they handle this issue. I don't know that there's any one right answer other than if you have concerns about the documents that were originally prepared, that's going to be an easy scenario where you should consider bringing someone else in. As a general matter, I think those policies exist at a lot of institutions to make sure that, going back to the idea of taking a fresh, clean look, you've got someone else that isn't, sort of tainted by the fact that they're their documents, taking a fresh look. So I certainly don't think it can hurt. There might be reasons you keep the loan with the same firms if they've got a great working relationship with borrower's counsel, or you're confident of the documentation. It's a tried and true set of documents you've used. Maybe then the efficiencies from keeping the loan with the same law firm outweigh whatever objective review you might get. But you can also ask your existing counsel to perform a loan review and give you a breakdown of all the issues, so that there is still a risk, I suppose, of non-disclosure there, but you still go through the exercise of reviewing the file. So, unless Drew or Kali, I don't know what you have to add. It's hard to say, hard and fast what the rule is there, but if you're concerned about it, it certainly can't hurt to have a second set of eyes.
I think Jeff answered that question very well and very comprehensively. I would only add that some banks, it is a hard and fast rule. If you prepared the loan documents, you're not going to be restructuring counsel. And
with that, the last comment we received is a good one, asking why when to switch counsel, we shouldn't just be answering that you should switch to Voorhees. We do have ethical obligations about directly advertising and pitching you. But as a general matter, of course, if you do have concerns with your existing counsel, any of the three of us or another member of our great finance and workout teams would be more than happy to talk with you. It's a very well-received question. So I think that takes us to 1 o'clock.
That is all the time we have for today. If you had a question that you did not submit or that did not get answered, please reach out to one of today's presenters directly. Our next webinar in the series will cover foreclosures and receiverships. It will be on Wednesday, November 16th. If you haven't already, you can register on Voorhees.com by clicking News and then clicking Events. We would like to thank you for joining us today. This concludes our program. Take care.